Hi, how are you today? The focus of today's video is to talk about the AI, Gen I, in this area, which has completely changed everyone's impression and imaginations of content creation. AI technology has reached perfection. It collects the latest information, news, and knowledge of the world, and it answers the questions, creates the text, pictures, or videos according to the user's requirements. This video will explore the legal challenges, ethical considerations, and my personal experience of using Gen I as it arises. The first argument to be discussed is the relationship between the IP law and the Gen I. When AI has the ability to create content, the question begins to arise. Is AI generated content eligible for intellectual property protection? If so, who will be the owner of the work? In traditional English law, we know that IP law grants ownership of works to human creators. According to the Copyright, Designs and Patents Act 1998, Section 9 Sub 1, the author of a work shall be taken to be the person who created it. And the Patents Act 1977, Section 13 Sub 2, requires an inventor to be a natural person. AI is not a natural person, so it is certainly not eligible to be granted the right of creation and the ownership. Since AI lacks human qualifications, it is very complicated to determine ownership in many cases. One of the famous cases is Taylor against Comptroller General of Patents, Designs and Trademarks 2021, in which the UK court ruled that AI cannot recognize as the inventor of a work under patent law. As a result, the public began to worry whether all works created using AI company software will be owned by AI company. However, this has received some criticism and suggestion from the public. The belief that with the development of AI, the legal community should create a legal method or legal clause to recognize AI works, to determine who is the inventor of the AI works. Recently, the EU's AI Act proposed that the law will conduct human supervision on the content and works of AI, but nothing else was mentioned at all. Therefore, the problems and the contradictions between the content and works produced by the AI and IP rights are still full of uncertainty. Perhaps in the future, the legal community will recognize that AI users will be the creators of the work, but at the same time, human oversight need to be strictly carried out and maintained. The second argument is about the responsibility and accountability of AI-generated content. In the first argument, we mentioned that under current UK law, the authorship of AI-generated works is uncertain. Therefore, the first question is extended. That is, when the AI-generated content is wrong, causing defamation, misleading, or harm, who will bear the legal responsibility? Under UK defamation and negligence law, liability is often placed on the publisher of the false or harmful content. If AI generates misleading or defamatory content, it will be difficult for the court to determine who is responsible for this. For example, if ChatGPT produced false information that harms someone's reputation, should OpenAI bear the legal responsibility, or should the AI user who published the information be held responsible? Or should both of them be held responsible? The UK's 2023 Cybersecurity Act introduces stricter regulation of technology platforms, requiring them to deal with harmful AI-generated content, but clear legal precedents on direct AI liability are still lacking. The rise of AI has attracted the opinions of many legal scholars. Some legal scholars believe that the founders of AI companies should be treated like book publishers. When a publisher publishes false information that misleads the public or contain the defamatory content, the publisher will bear the legal responsibility. Therefore, by analogy, the founders of AI software will need to bear the legal responsibility for the harmful information generated by the AI intelligence. Some of them believe that AI founders can issue a disclaimer to let users know that they are responsible for any information they publish, and the founders can reduce the direct legal liability. In general, the legal accountability framework for AI cannot keep up with the development of AI creativity. While looking forward to the future, where the law can create a certain legal means of protection for victims, we also hope that the founders of AI software can realize their obligations to prevent any harm and misleading. Next, we look at the third argument. Is about the data protection and the violation of personal privacy. The question is whether the content produced by the AI uses the personal information of the public without consent and whether it violates data protection law. General Data Protection Regulation (GDPR) require companies to obtain the user's consent before processing personal data. AI models are trained based on public information and data from around the world, which makes people worry about whether their personal information is being stolen for this. According to a popular case, Lloyd against Google LLC 2021, the plaintiff gathered 400 million iPhone users and sued Google, claiming that Google used Safari workaround to illegally obtain users' private information and put ads that they might be interested in on their phones, thus causing them to suffer material losses. They argued that this breached the Data Protection Act 1998 and sought damages for each affected individual. The court finally sided with Google because plaintiff and the victims could not confirm and could not prove what material losses they have suffered. So Google was not guilty at this case. Next, after talking about the three arguments, we will look at the ethical consideration in GenAI. First, if GenAI generates misleading and defamatory information, it will become challenging to determine accountability and how to help the victims to get the justice. Second, AI raises the question about data safety and security. We are collecting massive amount of the information for training. Third, when unskilled AI generates helpful knowledge information and false information, it will mislead the public and any users. Fourth, the rise of AI has greatly reduced the employment opportunities in fields such as writers, teachers, graphic designs, and journalism. Finally, I would like to share my experience of using the AI software ChatGPT. In my learning journey, I am very grateful for the invention of ChatGPT. I see its shining point. A student with a lot of academic work, ChatGPT is like a teacher which can quickly help you learn from zero knowledge to 40 understanding. But for top students, it is difficult for ChatGPT to help such students improve themselves because the answers given by ChatGPT are very superficial and not comprehensive at all. In my personal experience, I have used ChatGPT to get interesting travel plans, a healthy recipe, and a plan for my 4 elderly puppies to make a happy puppy life. I want to say that the development of AI is a blessing to society. Since it was invented by great humans, the challenges it faces can definitely be solved by humans also. In this era when AI is popular, instead of thinking about its shortcomings, we should accept it and use it in the right way. In the process of use, let AI to answer the answer you want by asking the question. And ask yourself, is the content created by AI correct? And please don't trust the AI completely. So this is all my opinions. Thank you and wish you a great day.